Hi, I'm Dan Chambers of Chambers Law Firm. This is the latest and last of a video series we've been doing on criminal appeals. In this particular video, we're going to talk about what happens once all of the briefs are done and the justices take the case. Once those 3 briefs that we talked about in the previous video have been filed, the case is then assigned to a panel of 3 justices. So it's no longer just one trial judge that oversaw your criminal trial. Now there are 3 justices looking at the legal issues to determine who's going to win the appeal. Once the justices are assigned to the case, they read the briefs along with their research attorneys and their staff that helps them get prepared, and they will send out a notice to the lawyers saying, do you want to come in and have what's called oral argument? That's where the lawyers show up in person and they argue in front of the justices and they try to win the case by their arguments in the courtroom. I will say that it's very rare nowadays for oral arguments to take place. It's kind of a thing of the past. In many years ago, oral argument was done in every single case. But now, because of the volume of cases the court has to deal with every year, oral argument is very, very seldomly done. But if it is, the attorneys show up in front of the justices and argue the points made in their briefs. And the justices may ask questions to get clarification on certain legal issues and probably will give you a good idea of which way they're leaning as well. Once the oral argument is done, or if there is no oral argument and the case is under submission, the justices will eventually write a written opinion. That written opinion will be disseminated to the lawyers, and it will give the legal reasoning of the justices about why they are ruling the way they are. That opinion might be as short as 5 or 6 pages, or it could be as long as 120, depending on the complexity of the appeal. But they will give you a written ruling telling you who won and who lost the appeal, and their legal reasonings for that. At the end of all of that, you can decide whether you want to try to petition the California Supreme Court to handle your case or hear your case. But just know, the California Supreme Court gets thousands of petitions each year in a criminal case, and they accept less than 1% of them. So the chances are pretty high that if you are not successful in your appeal at the Court of Appeal level, there's a very, very small chance the California Supreme Court will take a look at it and your appeal process will probably be over. If you have a loved one that's been convicted of a crime and you're thinking about appealing it, or you're in the middle of an appeal now, give Chambers Law Firm a call and we'll provide a free consultation to see if we can help you. Thanks.